Should any one company have the rights to Taco Tuesday? Taco John's believes so, and they've actually had the trademark since back in 1989. They registered Taco Tuesday for use in connection with restaurant services. They disclaimed the word taco, which means any competitor can use the word taco, but they're claiming no one else can use Taco Tuesdays. It's now owned by Spicy Seasonings LLC, but there actually was recently a cancellation brought by Taco Bell. So, Taco Tuesday, they use it home of Taco Tuesday since 1989, which is kind of odd because they actually, I think, said they've been using it since 1979 in their application, but that's besides it. They're using the R there to try and show that is their registration. And supposedly they've done a good job of policing that use. However, if you walk down any street in any town and there's a taco joint, they're going to have a sign that says Taco Tuesday. So it's impossible to stop everyone, and pretty sure that Taco Bell is going to succeed on their opposition here. But just wanted to run through a few things first. Let me see that there is this other company that has a restaurant services for Taco Tuesday. This Spicy Seasoning is the one now that's the Taco John. They say first 1979. As I said, that's odd because on here it says since 1989. You'll see if there's others, but what you'll see more of is that there's just a lot of use in other users of the term Taco Tuesday. And LeBron James tried to file for Taco Tuesday for advertising services, online entertainment, and basically received a rejection that said this is a commonplace message. And then you can see there's all these, Taco Tuesday fundraiser, Taco Tuesday with Justin Hodge, by wearing the Taco Tuesday dry fit shirt. Holy guacamole, he found a Taco Tuesday on Facebook. But let's take a look at what Taco Bell is saying as to why Taco John's, now Spicy Seasonings, does not deserve to have a registration any longer. And one thing to know is that when you have terms that become commonplace for it, commonplace for the item. So this is Taco Tuesday for restaurant services. You might have heard of the case of Kleenex for tissues or Xerox for copy machines, where those became the generic term, the term that everyone called it. Everyone asked for a Kleenex when they were talking about a tissue. Everyone said make a Xerox when they were talking about making a copy. And essentially those companies, which originally had strong trademarks, their trademarks started getting weaker, and Xerox and Kleenex had to go through a lot of work to keep people from using it, the trademark, as the generic name for the product or service. Now you would say make a Xerox copy or make a copy of that on a Xerox machine. Use a Kleenex tissue rather than just a Kleenex by itself. So here would be, Taco Tuesday restaurant services, to try and keep it as a strong trademark, to try and keep it so that doesn't fall into descriptive or generic. Velcro has been on a big campaign to do this as well. They put out a whole video because Velcro has basically become the descriptive or generic name for any type of hook and loop, which is what it was called in their patent and in their patent application. They originally had that patent for it, but that expired, and now many other companies are making what we call Velcro, and they're trying to do their best to keep that from becoming a generic name for it so that they'll have a strong trademark. However, I think they have an uphill battle because it's just so much easier to say Velcro than hook and loop, and I think they should have done that from the beginning. So that's besides the point. But for Taco Bell, this is what we call a cancellation proceeding. So when someone has a registered trademark, you can seek to cancel it. And there's a number of grounds. One of the grounds is that you believe the trademark has become generic, has become a commonplace term that everyone uses, that no one person should have the the registration over that. So, here's the preface. People like tacos on Tuesday. They just do. It's even fun to say Taco Tuesday. Tacos have the unique ability to bring people together and bring joy to their lives on an otherwise mediocre day of the week. Because of the registration, registrant is the only restaurant that has the presumptive right to use Taco Tuesday. That's not right. The registration potentially subjects Taco Bell and anyone else who wants to share tacos with the world, legal action, or angry letters with the say Taco Tuesday. So this is actually not the most common sort of a petition for cancellation. And I know in professional circles, there's been talk about whether this is the right way. I personally like it. And if I was doing it, I would do something like this as well, because it lightens it up. It's, these are the facts. I think they're bringing to light how ridiculous it is that one person should, in this day and age, have a registration for Taco Tuesday. Now, back when they registered it, back in 1989, there was a different story maybe back then, but things do change over time. That's why we always tell clients, you are the one that has to police your trademark. And some marks, Taco Tuesday was still a weak trademark from the beginning because it describes the product or service selling and a potential day of the week that you can be selling it on. So it was a weak trademark to begin with. And this is what happens with weak trademarks. Taco Bell believes that Taco Tuesday is critical to everyone's Tuesday to deprive anyone of saying Taco Tuesday, be it Taco Bell or anyone else who provides tacos to the world, is like depriving the world of sunshine itself. Don't know about that, but they're making some good points here. Taco Bell seeks no damage. It's simply, you can't even get damages in this type of proceeding, so I don't know why they threw that in, but it does sound good and go for it that they're really just looking for, some common sense here. And they go through listing out. They do cite to the fact that what I said before, LeBron James, when he filed, this was a rejection by the U.S. Patent and Trademark Office where the examining attorney said, hey, this is commonplace here. So they already had precedent within the U.S. Patent and Trademark Office to say that Taco Tuesday is a commonplace term and no one should get protection to it. So, and then it goes through, the term taco is generic for the services identified in the registration, restaurant services. Term Taco Tuesday is used ubiquitously by restaurants throughout the U.S. Term Taco Tuesday is an informational message conveying the ordinary and familiar concept or custom of consuming tacos and related products on Tuesday, and are used widely by the public. Board found in a Taco Tuesday is a very commonplace term that refers to having tacos and drinks on a particular day of the week. The marketplace was awash with use of the term Taco Tuesday for Taco Tuesday events and specials. So, and they go through it, and they're basically just asking that this registration be canceled. And my guess is either there's going to be an agreement worked out, or the TTAB will essentially cancel this trademark. I think it has become commonplace. I don't think one company should be able to control it. Maybe there'll be a way where they work out a deal that things like this, the way how they have it on their website, that Taco Bell can use it in their marketing to a certain extent, but maybe they won't have it as blazing on their website as this, something along those lines. But my guess is it's probably not going to get worked out, and it's probably going to get canceled. And go out and enjoy yourself some Taco Tuesdays. And if you like these, please subscribe below and let us know if you have any questions. Take care.